seated. He has invited us here to make some clarification. I call on the people and each of us today in Rumuagholu, Obia, all local government, River State, and the world at large to address them on a particular issue bordering on the land, a family land, a land deforested by my grandfather, late Ujoho Wekanyam Obuzo, in Rumuagholu community. This very land is known, widely known, and called Ohia Abada Esilar, situated here in Rumuagholu. But according to the custom and tradition, individual families own their land, as well the communal land, which is owned and controlled by the community. This very land shared the boundary with the Rumuagholu community, share with Alo Mbodo, also share with Ozoba and other families within Rumuagholu. This land in ages, we run farm, we run fishery within the water side. A time came when there was little issues between my family, the Wekayam family, and the Rumuagholu community. The matter was decided in the court, Choba customary court. Within the period, in the process of that court, families in Rumosi, known as Rumomba and Rumuagholu, they came to court, applied to join, that the entire land belonged to them, not to Rumuagholu, not to Wekayam family. But the court refused them because they could not produce evidence to prove that they have interest indeed. Their matter was struck out, and they could not appeal that judgment. Instead, what they did was to go to High Court, challenging jurisdiction, and that was the Court of Justice, Honorable Justice Fibaresima of River State High Court. And that matter was ruled in my favor. They continued. They went ahead, went to another High Court by Honorable Justice Apioku, challenging the same matter. And the matter was struck out in my favor. It didn't end there. I have to proceed for an execution because it became executory judgment. Choba customary court went ahead and executed that matter, that judgment, 2023. What happened? The same Rumomba and Rumuagholu of Rumosi went ahead to another High Court, Honorable Justice Kyo, asking for review of that judgment. And that matter, the judgment was delivered in my favor with a cost on them, 2.5 million naira to be paid. That review has Choba customary court, has River State Police Command, has Rumuagholu community, and they have me and my families. And that 2.5 million naira was shared according to these parties. It never ended there. What Kyo judgment said, that Commissioner of Police, the court, should go back and continue the execution. And we have to go. And we continue and finish the execution. Certificate writ of execution and possession was given. The judgment, immediately after the Choba judgment of CCC/22/2015. So immediately after the judgment followed about 9 other judgments challenging that Choba customary court judgment, which all were in my favor. All were in my favor. Now, at this point, at this time, a certain group of persons who first claim to be landlords from Rumuagholu, that they bought land from Rumuagholu, they went to court to challenge the judgment, which I won them. They later changed their names to Victory Estate. That's where we are. At this point in time, I am here to present to the world what has happened and what is still happening from a local government chairman, Obiakpo, being Honorable Gift Rumuagholu. Obiakpo, local government chairman, Honorable Gift Rumuagholu, comprehensively stand against valid court judgment. Another gangsterism, stricted beyond the Rubicon. The Ekanyang family of Rumuagholu community in Obiakpo local government area of Rivers State, Nigeria, notes with ample dismay the infamous action of Mr. Gift Rumuagholu, the chairman of Obiakpo local government area, who in Gestapo manner, depicting in the 1993 Magashua, Somalia, lawlessness, invaded our Abada Esilaro farmland, situated along the Obirikwere Airport Road with thugs and hoodlums, maliciously destroy properties situated therein and made away with valuable worth millions of naira. It is obnoxious that Mr. Gift Rumuagholu carried out this reprehensible act in defiance of numerous court judgments in favor of Mr. Colonel Ogmerim Eke and his Ekanyang families. In questing to emancipate the reading and the listening public from the thraldom of misleading indoctrination, deliberately peddled by Mr. Gift Rumuagholu and his minors, we state that. We state emphatically that sometimes in 2015, Dr. Colonel Ogmerim Eke and Lord C. Wosu filed suit number CCC/22/2015 between ourselves as claimant and Chief Friday Ibayochi Aya and 7 others for themselves and on behalf of Rumuagholu community as defendants sometime in 2015 over the ownership title to the large expanse of land known and called Ohiagbade Esilar land, measuring well over 6,000 plus of land and situated at Rumuagholu community, Obiakpo local government area of Rivers State. While suit number CCC/22/2015 was pending at the Choba Customary Court, Chief Sunday Amade, Chief Bernard Nna Eme, Eda Emenike Walker, Mr. Ernest Wong Ihunda, Mr. Isaac Mba, and Mr. Ohwanda Amadi, hereafter called the first set of parties for themselves and as representing the Rumumba and Rumuagholu compound of Ikwengara community in Rumosi Town, Obiakpo local government area, applied to join the suit on the basis that they were the rightful owners of the said Ohiagbade Isilar land, which they christened Ohia Nsumide, Ohia Egbelu Rumosi, and Ohia Wokede lands. And the Choba Customary Court rightly dismissed the application for joinder on the 5th day of October 2017. The certified copy of the ruling delivered on the 5th October 2017 is here annexed and marked same as Corner 1. After dismissing the Rumosi people, first set of parties application for joinder on the ground that the Rumosi people had no interest in the said land, the Ohiagbade Isilar land, which Rumosi people call Ohia Egbelu Rumosi and Ohia Wokede Rumosi community. First set of the parties and her representatives accepted the ruling and did not appeal same. The matter suit CCC 222/2015 proceeded with the representatives of Rumosi community joining that is between us, judgment creditors, and representative of Rumuagholu community, judgment debtors, until judgment was entered in favor of our family. After judgment was entered in the suit, representatives of the present Rumosi community, first set of parties in the person of Chief Sunday Amadi, with the 5 others who had earlier applied to join the suit at the Choba Customary Court, filed suit number PHC/4344/2019 at the High Court of Rivers State, seeking leave to appeal judgment as interested party, affected the judgment, and in a considered judgment, my Lord Honorable Justice F.A. Fibaresima, before whom the matter was pending, dismissed the application for being an abuse of court process on the ground, among others, that having not appealed the ruling of Choba Customary Court, refusing their motion for joinder on the basis that lacked interest in the land or Ohiagbade Isilar land. In bracket, they could not competently seek leave to appeal the same judgment. I annexed the judgment of the High Court of the River State, presided over by Honorable Justice Fibaresima, F.A. Fibaresima, in PH/4344/2019, dismissing application for leave to appeal the judgment in CC 22/2015 and marked same annex corner 2. Again, first set of parties, Chief Sunday Amadi and 5 others, the Rumosi community, accepted the judgment of Honorable Justice F.A. Fibaresima and did not appeal same to date, but filed a suit for judicial review in PHC/3412/2019, between Chief Sunday Amadi and others, and Colonel Ogmerem Eke and others, and the High Court of Rivers State, par Honorable Justice S.H. Aprioku, also dismissed the said suit, annexed the judgment in PHC/3412/2019 as Annex Corner 3. We opine state on record that the Rumosi community, first set of parties, and her people are bound by the ruling of the Choba Customary Court in CC/22/2015 to the effect that representative of Rumosi community did not disclose that they had interest in the Agbade Isilar land, Annex Corner 1, which land they have always called Ohia Egbelu Rumosi and Ohia Wokede land, even in the application for joinder. I equally state that the Rumosi community had her people herein are bound by the judgment of Honorable Justice F.A. Fibaresima in suit number PHC/4344/2019 Annex Corner 2, which in law is an appeal itself. Immediately after the judgment was delivered in suit number CCC 22/2015, the present judgment debtors respondents, Rumuagholu community, appealed the said judgment to the customary court of appeal in appeal number CCA/PH/51/2019, and on the 3rd day of November 2020, the appeal was dismissed by the customary court of appeal, Rivers State. I hereby annex a certified true copy of the record of proceeding of the customary court of appeal on the 3rd day of November 2020 and mark same as Annexure Cornell 4. The Ekayahu judgment creditor applicant could not enforce the judgment delivered on the 9th day of September 2019 within the time stipulated by the applicable rules of court, because the judgment debtors respondent filed an appeal at the customary court of appeal, Rivers State, but after the said appeal was dismissed on the 3rd day of November 2020, we apply for revalidation of the lifespan of the judgment, and same was accordingly granted on the 7th day of June 2022. I hereby attach the certified copy of the order of the Honorable Court revalidating the judgment of the customary court in suit number CCC/22/2015 and mark same as Annex Cornell 5. The Rumuagholu community tried to resurrect the appeal by filing a fresh application for leave at the customary court of appeal, Rivers State, to appeal the judgment in CCC/22/2015 and CCA/PH/26 mix MISC/2020 between Mr. Atuze Ovuwon and others versus Mr. Cornell Ogmerim-Eke and others, but the learned judge of the customary court of appeal in well-considered ruling delivered on the 28th day of September 2021 dismissed the application and hereby attach certified copies of the record of proceeding of the customary court of appeal dismissing suit CCA/PH/2026 MISC/2020 between Mr. Atuze Ovuwon and others versus Mr. Cornell Ogmerim-Eke and others on the 28th day September 2021 and mark same as Annex Cornell 6. Sometimes in 2024, the Deputy Sheriff and other lawful officers of the Choba Customary Court commenced the enforcement of the judgment in suit number CCC/22/2015 over portion of Ohiagbada Isilaro land, and enforcement was still ongoing when the first set of parties, Chief Sunday Amadi, Chief Bernard Eme Nnaeme, Eda Emenike Walker, Mr. Ernest Wogu Ihunda, Mr. Azam Abba, and Mr. Wanda Amadi for themselves as representing the Rumumba and Rumechinwene compound of Ikwengara in Rumosi community. File suit number PHC/1640/CS/2024 between Chief Sunday Amadi and others, Honorable Eze Muwandamate and others, seeking to quash the judgment in suit number CCC/22/2015, set aside the enforcement of the judgment in suit number CCC/22/2015 and to prohibit the Choba Customary Court from issuing a writ of possession certificate order of execution. After issue, we are fully joined by all the parties concerned, my Lord Honorable Justice D.G. Kio of the High Court of Justice, Rivers State, in a well-considered judgment dismissed the suit for lacking in merit. The court, amongst other things, held that we, myself, and my family should proceed to enforce the judgment in suit number CCC/22/2015 PCS/22/2015, and that the Choba Customary Court can validly issue the order of execution and writ of possession to us over the entire land, measuring well over 6,000 plus. Subject matter of judgment in suit CCC/22/2015. I hereby annex a certified copy of the judgment order of the Honorable Court in suit number PHC/1640/CS/2024 and mark same as Annexure Cornell 7. In delivering judgment in favor of our favor and against the first set of parties, the Honorable Court awarded cost of 500,000 naira only to each in our favor. The Police Commissioner, Rivers State, the Choba Customary Court, respondent in the suit against the first set of parties and their Rumuagholu community, including Mr. Rumuagholu, Mr. Monday Okoro Ibinedom, Engineer Okechukwu Obara, Engineer Bosoni J. Benibo, Prince Andy Okeke, Prince Desmond U. Nzelegu, Ohakwe Moscow, Dr. Christian U. Abu, Gabriel A. Oke, S.N.S. Owuche, Esquire, Omunakwe Amade, Fam Anele Enyi, and others at large, herein after call the second set of parties of particular concern to this discourse. The fact that first set of parties have now appealed against the judgment of my Lord, Honorable Justice D.G. Kyo, in suit PHC/1640/CS/2024.